Yes, Mr. Beckman.
Morning, my lord.
Can I say straight away, before you even begin, it is of course a very hot day and the courtroom is not super cool. So if counsel would like to take wigs off, please do. I may as well say now that if you'd be more comfortable without gowns, then I'm completely content, we are completely content for you to disrobe to that degree as well. We want you all to feel comfortable so far as possible. No, Mr. Beckman.
My lord, I'm grateful for that. As my lord knows, I appear on behalf of the appellant in this matter, together with Mr. Jack Barber, Mr. Paul Brown, King's Counsel, and Mr. Nick Grant appear on behalf of the Secretary of State for the Home Office, the first respondent. The second respondent is the Secretary of State for Defence. Ms. Anderson appeared below. As I understand it, they are not proposing to take an active role for the purposes of today's hearing.
No. No, well, you're all aware of what has been going on by way of interventions. There are three interveners with the permission of the court to intervene. West Lindsey District Council, Mr. Gabriel Clark Holland, and now very recently Rother District Council.
Yes. All
of whom have, in accordance with the orders made by the court respectively, submitted written representations or submissions to the court, which you will all have seen, I assume.
Oh, yes.
And which you will be able to deal with as appropriate in the course of your oral submissions to us today.
My lord, I have been asked to check, just on behalf of West Lindsey District Council,
yes,
whether or not the court has seen some additional material. I think it may just have been 1 or 2 pages that was submitted.
Yes, indeed. Do you want to deal with that? I have actually kept it separate rather than putting it in the bundle. It didn't seem to me controversial that it should go into the bundle. Do you want to deal with that material at this stage?
Well, my lord, I have no objection to that material being considered by the court.
All right.
It's
well, just to be clear,
West Lindsey.
I think you're referring, aren't you, to the there are the following. There is a letter from the Speaker's Council. Have you seen this?
My lord, I have.
Dated the 9th of June 2023.
Yes.
And there is a response to that, which is a further letter to the one that is at the back of the supplementary bundle. And there is a response to that further letter from Speaker's Council from West Lindsey District Council, submitted on the 11th of, well, it's dated the 11th of June, but I think it's probably reached us only today, either late on Friday or today, I'm not quite sure. You've seen that?
My lord, I've seen all of that. My understanding is that there's a further brief response from West Lindsey that was only sent this morning, and that's why I was asked to inquire as to whether or not it had reached the court.
I'm not sure we've seen that.
My lord, I think that brief response is the document dated the 11th.
Yes, I see. So that's the one I've just referred to.
I believe it is.
My lord, yes, I'm able
All right.
to confirm.
Well, to help you, it's a 7-page document. It just goes on to page 7. And it runs to 19 paragraphs, and it's dated the 11th of June. So that's the document I think you were referring to just now. And then in addition to that, we have, as I've said, very recently submitted written submissions on behalf of the third intervener, that's Rother District Council.
Yes.
We've got those submissions, and we've got, really as an administrative correction, if you like, to the authorities bundle, the correct version of section 296, and think that was it, wasn't it?
My lord, we did also cause to be circulated one page of the PPG.
Yeah, that's right, yes. We've got that as
My
well.
lord's seen that.
We've got that as well.
Great.
PPG, paragraph,
44-008.
that's right. Fine, so we've got all of that material. We received from you, and thank you, the agreed facts. They came, I think, on time on Friday afternoon. Friday morning or Friday afternoon, I'm not sure which. So thank you for that. That is a help to the court. Just while we're thinking about matters of agreed fact, it did occur to us all that a useful note, which we would like you please to provide, would be describing all the proceedings which are currently on foot, so that we know exactly what the live proceedings are. That means not only in Braintree but also West Lindsey and Rother, including any applications for injunctions. We don't require that here and now, obviously, but we would like that please to be submitted in early course, either during today, or if not today, then please within a short time. I'm going to say, I think, 24 hours of the conclusion of the hearing.
My lord, of course, we'll see how far we can get over the course of the shorter journey.
Yeah, it shouldn't be difficult to do that. It may be that you'll need to make contact with others just to check that the position is as you thought it was. Right. While we're dealing with such matters, can I just mention two things to you? Really, this is both out of probably an excess of caution. As Senior President of Tribunals, as you will appreciate, with responsibility for the Tribunals and with responsibility, therefore, for the Immigration and Asylum Chamber at both levels, I am necessarily aware of matters relating to the conduct of Tribunals business where that impinges on asylum and immigration, naturally. And therefore, in the course of Tribunals business, I'm made aware of matters of fact, statistics and so forth, pertaining to Tribunals business. And thus, some of the background to this case will have necessarily been shared with me in that role. Why am I mentioning that? Well, simply so that everyone, not only in the courtroom but also watching on live stream, is aware of that. It doesn't in any way, in my view, affect my hearing this case and the appropriateness of that. I want to make that clear. The other thing, also out of an excess of caution, because of the recent correspondence there has been from the Speaker's Council, I ought to make it, well, I'm going to make it known that the Deputy Speaker is a personal friend of mine and my wife's. I don't think that has any bearing whatsoever on the legal issues involved in the recent correspondence. Therefore, I'm again simply doing that, I'm quite sure, out of an excess of caution, but I'm doing it in the interests of total transparency.
Of course.
Those two, again, it doesn't in any way cause me any difficulty. I want to emphasise that. So those are the two things I wanted to mention. Is there anything else we need to get dealt with before we make a start?
My lord, no, not for our part.
Brown?
Nor me, my lord.
Right, thank you very much. Just before you do begin, as you would expect, the court has prepared itself for the hearing in the normal way. We have made ourselves familiar with the material which has been submitted to the court, and you can assume that we're familiar with the factual background the content of the witness statements, and of course also with the skeleton arguments.
Well, I'm grateful for that. On that basis, I will, if I may, deal with the facts briefly by reference to just some of the documents that are before the court, seeking to emphasise a few matters, then move on to the statutory provisions that apply to both of the issues that are raised by this case.
Yeah.
And then after that, turn to the submissions on behalf of the appellant on grounds 1 and 2. And my lord knows the shape that the appeal takes from the grounds of appeal that are at page 15 and following of the core bundle, and we have the benefit of the judge's transcript of judgment behind tab 7 starting at pages 82, and as is clear, the judge set out a good deal of the factual background within that judgment, so I seek not to rehearse matters that have already been set out by the judge below. As my lords and my lady know, we have two essential grounds of appeal. The one which is most closely tied to the other existing proceedings is whether or not it's open to the Secretary of State for the Home Department to rely upon Class Q in order to avoid or not have to make an application for planning permission in relation to the use of land at RAF Wethersfield for use to accommodate up to 1,700 male asylum seekers. And as the court knows, RAF Wethersfield was one of 3 pathfinder sites identified during the course of submissions made to the Minister and the Secretary of State for those purposes, albeit in slightly varying numbers, but on each occasion a substantial number of asylum seekers.
Yes.
And my lord, it's against that background that the Secretary of State relies, for the reasons that I'll set out in the emergency statement that I'll come to shortly, on Class Q, saying that this is to be categorised, the provision of this accommodation is to be categorised as an emergency for the purposes of the secondary legislation contained in the General Permitted Development Order of 2015 under Class Q. So, my lord, against that background, if I turn straight away to the submissions that were made and that found their way to the Minister and the Secretary of State, they're contained within the supplemental bundle.
Yes.
And Mr. Banner, in his witness statement, sets out many of the matters relating to those submissions, but I wanted to draw the court's attention to just a few passages within those submissions, starting at page 127.
Right. If the court has that, we see in the first submission that contained within this bundle the nature of a site selection process that was being suggested and then ultimately progressed on behalf of the Home Office, and the start of that is set out in the background, where it's noted that paragraph 2, additional 22 sites on the new MOD list. Sure, we're given the total number of sites, but a significant number of sites, of which 3 meet the initial criteria, but it is noted that 2 of these sites sit within the Prime Minister's constituency. A further review of the MOD dataset has identified 13 sites that require further technical information before they can be progressed or discounted. See further Annex A. And then, in terms of the considerations that were set out in paragraph 5, we see reference to potentially the need for planning permission to use the sites in the way anticipated and securing environmental impact assessment. B, effective and timely engagement was identified there, but the court will have seen how
then, importantly, for whether or not an emergency is being responded to here, under next steps, we see we will actively take forward a feasibility assessment on 13 sites to consider the use of the MOD sites once additional information is received. This will involve, and then the list is set out there, and then 7, upon completion of this exercise, further analysis through inspections and surveys will be undertaken to establish what work might be required and costs associated. And then one sees a long list in terms of the further work that is said to be required before the matter can be refined further. So that's in November 2022. Then we move forward at page 131 to the 25th of January 2023. And by that stage, as the court sees, this is a submission dealing with Wethersfield and Scampton by this stage, and asking for preferential access so that those sites can be inspected. Following the decision of the small ministerial group on asylum and accommodation to prioritise these 2 sites, the Home Office needs to formally request preferential access to these sites from the Ministry of Defence. Another point to note in terms of whether or not this is overall a reaction to an emergency is that we are not told within these papers, and haven't been told elsewhere, the basis upon which the decision of the small ministerial group was made, and in particular the basis upon which they alight on the 2 options that they do at this stage. But what is apparent is a more general consideration for issues that are certainly beyond proper planning issues, in the sense of being material planning considerations, that are being introduced into the site selection exercise. Under background, again, paragraph 2, we see the reference to the initial SIFT exercise and the criteria that were applied there. But again, in terms of the consultation and local authorities' ability to analyse that, the actual basis of the exercise and how sites were scored, for example, has not been provided to the local authorities. The decision-making process continues, and the next submission is the 27th of January 2023. That starts at page 137. And it notes again in paragraph 1 the decision of the small ministerial group, supported by the government departments, and the approach that is to be taken. And then following discussion in that submission, the recommendation appears at paragraph 13. And it is given the pressures on the asylum system. And the word pressure is used, as the court will have noted, throughout these documents. So is the word challenge or challenging. And there can be no doubt that the Home Office has found itself in a situation where there are very significant pressures on the asylum system and where addressing those issues may be challenging. What the appellant says has not happened is that an emergency situation for the purposes of the planning legislation has not arisen. And so we see there reference in 13 to the recommendation for Bexhill. So Bexhill is, as it were, in the mix by this stage. RAF, Scampton and Wethersfield. And one of the things that the court will have seen from the recent submissions made on behalf of Robert District Council is that whilst this submission is dated the 27th of January 2023, getting on for 5 months on, there has been no decision in relation to Bexhill. Again, in terms of considering the generality of the facts without descending into more specific facts about Bexhill, the appellant says that that is not indicative of an emergency situation. Another element of the factual matrix, which is not, we say, consistent with an emergency situation overall, is the level of, if not delay, certainly time passing between between elements of the decision being made. We were just looking at a submission in January, and the next submission that we now turn to look at on page 146 is the 3rd of March 2023. And so we would suggest, if one is seeking to characterise the situation as an emergency, that is a significant period of time between the end of January going forward to the beginning of March. And this submission is in similar form to previous submissions. We see paragraph 2 again on page 147, the reference to the small ministerial group, and then paragraph 4, supported by other government departments, we've accordingly been developing proposals for these pathfinders for the purposes of asylum accommodation. The submission at that stage relies on a number of assumptions that are then set out insofar as they apply to Wethersfield. And there is the mention on page 148, subheading, asylum emergency in class Q. And then the approach to class Q is sketched out within the submission. And further detail is provided as to how the sites might be capable of being brought forward. And just for the court to note, the court will have seen this, but at page 154 under communications and engagement, paragraph 38, very little formal engagement on the Home Office's proposed use from the pathfinding sites has been undertaken. This is in line with the direction from ministers. Again, if there were an emergency situation which required an immediate or rapid response to a sudden situation developing, then one might anticipate that there would be much fuller consultation between central government and various arms, both of local government, but also consultees who will assist with the provision of services, such as health services, police force, and so on. Well, after that, the decision-making process continues to take its course. Equality impact assessments are developed and refined over time, and then we find ourselves in late March, where a decision is being made based on the submission then supplied and the emergency statement. And the emergency statement starts at page 222 of the bundle.
Page, sorry.
222, my lord.
Thank you. Yep.
And we have first of all the introductory section, paragraph 2, number of asylum seekers requiring accommodation to reach record levels in the UK. Obtaining planning permission takes time, undoubtedly true, but my lord, the court know what we say about section 293A and so on, and one can simply observe the passage of time that there has been without occupation of any of these sites to date. It's important to note what's said after paragraph 3, where it's suggested the Home Office is unable to meet the immediate need for sufficient adequate accommodation for asylum seekers, because the judge relied on paragraph 3, as we see from his judgment. But then the introduction carries on, paragraph 4. As a result, the Home Office is currently reliant on the growing use of hotels to provide temporary accommodation for asylum seekers. So that's the response noted very early on within the emergency statement to the asserted inability to meet immediate need for sufficient adequate accommodation. And then, having recognised how that issue was being addressed, paragraph 6 says the current scale and costs of hotel use, alongside limited supply, means that the continued growth of hotel usage is not sustainable. And again, as one reads this document and looks for tone and what's being described, we submit that a situation that is described as not being sustainable is not akin to something which is an emergency, either in the ordinary use of that word, or insofar as it's different in the way that that word is used within class Q. it speaks to the situation that needs to be addressed in the medium to longer term, where one would anticipate that that might be done, as it is done, by a sequence of policy choices. After noting that the position is not considered to be sustainable, two factors are relied upon. Costs are increasing, and again, the costs that are set out very clearly in these submissions are large costs. But the issue of cost, we suggest, cannot, where it may be driving an exercise, be indicative of an emergency. What it is indicative of is the need for further provision to be made in a way that is consistent with the normal application of the Town and Country Planning Act legislation, including all of the obligations to consult and so on that are contained within that legislation. So paragraph 6 carries on to mention reduced supply following the pandemic, and then refers to the need for the Home Office to urgently secure additional temporary accommodation to ensure it can continue to meet its statutory duties. So that was what was identified as being required, additional temporary accommodation of whatever kind. Then moving forward into the discussion on Class Q, which starts at page 224. 225, paragraph 19 at the foot of that page. It is considered that an emergency exists falling within Class Q, since there currently exists in the United Kingdom a situation which threatens serious damage to human welfare because there was and remains an immediate need to provide accommodation for destitute asylum seekers, which, if not met, would result in homelessness. And pausing there, what one will not find in these documents is a suggestion or a demonstration that in the absence of the use of these three pathfinder sites, or in particular RAF Wethersfield, that there will be a breach by the Secretary of State of her duties to provide accommodation. So paragraph 19 carries on. Whilst a proportion of this need is currently being met through the use of hotels, this was and still is only intended as a short-term or stopgap solution, pending provision of more suitable alternatives. And again, we rely on the tone of that message. What is being identified in an entirely unexceptional way is the need for what was envisaged as a short-term measure ultimately to be brought to an end by a process so that more suitable alternatives can be employed. But that is not the language of emergency. And so after setting out that requirement for more suitable alternatives, the conclusions that are contained in the introduction are reached. The proposed development would therefore be undertaken for A, B and C, which are the purposes set out within Class Q. But we suggest that that is a leap which certainly the former language does not support. And then paragraph 20, for these reasons. So that's the basis upon which, albeit in the introductory section, the Secretary of State's justification is set out. There is then more detailed discussion of the various issues arising, and the court will have noted, I've moved through these passages more quickly, but the court will have noted in dealing with the nature of the emergency, page 227, paragraph 27, demand for asylum accommodation has grown sharply and significantly since 2020. So again, just an indication of the duration of the issue. Not yet expected to have reached its peak. We know from the figures that are produced later that the figures are expected to rise through 2023, and indeed we also know, as we move on to page 228 in paragraph 28, that even in the longer term, the Home Office's current modelling projects an ongoing upward trend in demand for asylum accommodation. Again, not a situation which we say is consistent with the use of the word emergency, or something that naturally falls within the meaning of that word. And just to note as well, at the top of page 228, the references to the need for a timely supply of longer term accommodation. And my Lord, in opening the case, I referred, in addressing some of the tone of this document, to the references to the Home Office facing challenges, and you can see the first of those references at page 232, paragraph 40, commenting on the graph showing the small boat arrivals. There at the end of that paragraph, stagnation in the available property market, which has created challenges in securing the supply of asylum accommodation. Again, if one just moves forward to page 240 for a second, one can see there, paragraph 60, this is dealing with other sources of potential demand on the system at that stage. But again, we see reference in the last three lines: further reduce supply in the market and increase the challenges that the Home Office and its providers face in sourcing suitable contingency process. Again, we invite the court to note the tone of the language that's being used. And then, in relation to the situation that arose at Manston Processing Centre in October and November 2022, the emergency statement deals with that on page 237. And as the court knows, what that caused to happen was a change in the mechanisms that were used in relation to the booking of hotel rooms, so that block booking had to be supplemented by the use of spot booking of a number of places, which of course was likely to mean that for the period that it was operating, the spot booking system would be more expensive and indeed less simple to operate. That is why, on page 239 of paragraph 55, the emergency statement refers to the anticipation of moving all of those sites under spot emergency booking, either by people exiting those hotels or moving bookings onto a longer term footing. That hadn't been possible at that stage, and so the paragraph concludes: as a result, a significant number of asylum seekers remain accommodated in spot booked hotels. But again, no indication there of a breach of duty or an imminent breach of duty, far less any systemic issue in relation to compliance with the Secretary of State's duties. There were other features that were in play in this decision-making process beyond cost and beyond supply, and they relate essentially to political issues. One can see a flavour of that at page 238, paragraph 54.
Sorry, page?
Page 238.
Thank you.
Paragraph 54. Where it's noted that the arrangements that have been in place in relation to spot booking were contentious, and a number of local authorities sought interim injunctions. And so the measures that were being taken at that stage were recognised as being both politically and indeed legally controversial. But again, whilst those are matters that may feature in a a justification for seeking and exploring alternative sources of accommodation. What they don't speak to is a situation of emergency. And then, drawing this section together, the section that we were just looking at, which actually moves on to the existing supply of accommodation, we can see that, page 239, and the references again to block booking and the cost. We see as we move over the page to page 240, just at the top of that page. In this context, the ongoing expansion of emergency hotel accommodation remains an expensive and precarious mitigation due to the present lack of sufficient dispersal accommodation. So it's the absence of long-term solutions that is causing part of the issue here. But what appears to be being contemplated is an ongoing expansion of the use of hotel accommodation at that stage, with a potential solution, therefore, in place to address the challenges that the Secretary of State is facing. The submission, before it moves to its conclusion, turns to page 241 to how RAF Scampton and Wethersfield relate to the emergency. And paragraph 63 refers to the development of the sites as additional asylum accommodation for destitute asylum seekers will prevent a future emergency. Now, pausing there, that's a phrase that the Secretary of State used. It's a phrase that the judge used as well in his judgment, and it's beyond class Q. Class Q is not envisaging future emergencies that may or may not arise. At the height of that provision, what it is dealing with, potentially, is the prevention of emergency. And where it deals with the prevention of emergency, we say that that is to do with taking physical or other steps in the imminent moments before an emergency arises, so as to prevent its occurrence or prevent some of its effects. Or what it is not doing, when one considers what the implications of being able to rely on class Q are, is casting the net much wider to the prospect of a difficulty which may be classified as an emergency arising in future.
Could we just look at class Q before we go much further? Please. Tab 2.
But bundle of authorities.
Tab 2.
Tab 2, page 32.
Yeah. You've referred to QA.
Yes. Preventing an emergency. So it's the emergency which is identified and in relation to which steps are being taken at that point in time to prevent it. So, for example, if it's a flood, it might be in relation to immediate operational development that is required on Crown land near the foreshore. It's one of the examples that's given. Not the flood example, but the operations taking place on the foreshore is one of the examples that's given in the PPG.
Yeah. There are two other strands, of course, of
There are two other strands.
Q.
One of the submissions we make is that it's important to read this provision as a whole, just as it is to see the context in which it sits in terms of the 1990 Act and the instruments made under it. 2, or B, is to reduce, control or mitigate the effects of an emergency. So that's something, steps that are taken, again, in relation to the identified emergency. But it is something that, by its nature, has to be an emergency for these purposes.
Yes, the common denominator
Is
is
emergency.
is emergency.
Yes. And C, taking other action in connection with an emergency. And again, the court will need to consider the breadth of that provision and whether appearing where it does, it is really doing anything more than providing planning permission for steps that may be ancillary to deal with an emergency that has arisen, such as, for example, it may be decided if there's an emergency situation in a particular location and emergency services, responders need to be located there, it may also be convenient to have administrative facilities there, logistical facilities, and so on. That, we submit, is the kind of development that C is really directing itself towards.
Thank you.
And so, my Lord, coming back just to finish my observations on the emergency state, page 241, we see the reference to future emergency, mitigate the effect of an existing emergency. We say that begs the question and see the earlier tone of the document, and will involve taking other action in connection with the emergency. It will do so by averting homelessness caused by destitution which would otherwise occur. Now that is the assertion for which the rest of this document does not supply the evidence. Because the homelessness will only arise if the Secretary of State is unable to fulfil her statutory duties. And this document doesn't suggest, nor does the evidence of Mr. Banner suggest, that that will be the outcome. Paragraph 64 refers to the proposals as being required to supplement existing asylum accommodation state capacity for which there is an immediate need. And then one can see paragraph 65 across the page references to essentially cost benefit analysis at that stage, further surveys and market engagement. We anticipate both options could provide value for money when compared to hotels. Again, we suggest that exercise and everything that's going on with the site selection and these forms of analyses are not consistent with an urgent response to an emergency situation. So that's all I wanted to say by way of addition to the factual matrix that Muller already has.
Yes.
I will also have seen, just to note, the correspondence that's attached to Miss Mayo's witness evidence that shows what was being said to the authority
Yes.
at an earlier point in time. And again, I simply take from that there was no clear definition of milestones, no clear statement of when it was anticipated that this land would come online at RAF Wethersfield. And again, that is not consistent with a need for the land to be used imminently in response to an emergency.
Right.
I can invite the court then to turn up the bundle of authorities.
We're putting the supplementary bundle away now.
Oh, yes.
Yes.
So behind tab 1 we have some of the provisions of the 1990 Act.
Yes.
Section 57 contains the broad requirement for planning permission for development, and I will have seen what the competing submissions are in relation to whether or not the reference to requirement there has any real role to play when we look at the provisions that are dealing fine specifically, we suggest, with enforcement and what the enforcement mechanisms under the Act commonly require, and they commonly require the imposition of detailed, structured requirements that, if not met, can be the subject of further enforcement, certainly absent section 296A, and certain other notices and orders contain prohibitions, again, detailed, structured prohibitions, which need to be adhered to, again, and the normal circumstances of non-adherence would be risk of committing a criminal offence.
Yes.
So we have next section 58 dealing with development orders. Well, just to note there, it's a small point about the way that Class Q in its amended form may be intended to operate. But as the court will know, Class Q was amended to be extended in two ways. First of all, the period of 6 months was extended to 12 months. And secondly, the additional mechanism was inserted so that development and usage could remain at the end of a 12-month period if there had been a grant of planning permission on an application made under Part 3. That is to say, by a normal planning application to the local planning authority, with all of the normal consultative arrangements, or if one were made and then called in the decision by the Secretary of State. Section 59 provides further provision in relation to development orders. Section 62 I don't need to dwell on. We move next to the enforcement provisions, and we have section 171A. And this sets out expressions used in connection with enforcement within the 1990 Act. And first of all, we have the definition of what constitutes a breach of planning control, subsection 1, then subsection 2. For the purposes of this Act, 3 things constitute taking enforcement action, and they are listed: the issue of an enforcement notice, issue of an enforcement warning notice, circumstances where that may be appropriate, service of a breach of condition notice. And my Lord Court will know that one of the consequences of whether or not enforcement action has been taken is the application of the time limits that appear in the next provision on page 14, section 171B. So that is an example of how those terms connected with enforcement then fall to be applied in the balance of the scheme. There are other examples of where enforcement steps need to be addressed or dealt with. So, for example, there is a wider definition of enforcement action in relation to what is required to be put on the planning register. I'm sure we've got 188 before us, but if the court goes back and consults that, you will see that even on that wider definition of what is capable of constituting enforcement action, an injunction doesn't feature, which might be thought of, one sense, to be a curiosity. So an enforcement notice will need to be put on the planning register, but an injunction would not be in accordance with the statutory form. But that's simply another indicator, I submit, of the fact that injunctions, for what are readily understandable reasons, are treated in a different category from those steps that are identified in section 171A2.
Are we going to 296A?
My Lord, we will be.
I mean, at the moment you're showing us these provisions. Are you showing us these provisions in connection with your submissions on Class Q, or in the broader sense that they are?
I was hoping to do it in the broader sense.
Yes, fine.
In one go, so that I can then turn to the submission.
Yes, fine, all right.
That's convenient.
Yes.
But moving through, we have on page 19 section 292A, which reverses what was previously the general position, so that the application of the Act binds the Crown. And of course that has at least two dimensions to it for present purposes. One is the need to apply for planning permission, and the other is the consequence of what might be done in order to regularise the situation if a necessary planning permission is not required. And it's in relation to that section 296A comes into play on page 26. But my lord, just before we turn there, because the provisions appear in this order, can I deal briefly with section 293A on page 23?
Yes.
So this is statutory provision inserted at the same time that changes were made, making the Crown subject to the town and country planning measures. And what it provides for is a particular mechanism for urgently progressing development proposals on Crown land. And we can see that it's activated potentially by the appropriate authority certifying two things: that the development is of national importance and that it's necessary that the development is carried out as a matter of urgency. There doesn't appear to have been a great deal of debate in this case so far as to whether or not what is being pursued here by the Secretary of State could fall within section 293A. But insofar as we are dealing with three sites, one in Essex, one in Lincolnshire, one in East Sussex, all of the size that they are, what that tends to give the impression of is something that is an issue of national importance. And insofar as the Secretary of State's case is that these matters need to be addressed as ones of urgency, then 1B would presumably, the Secretary of State would say, be satisfied.
I mean, would it be right to say that an emergency, properly so called, for the purposes of Class Q, would always fall within the ambit of those two considerations taken together?
Well, I would certainly accept that in the generality of cases. It may be possible to conceive of exceptions, but as a general principle, yes.
I mean, clearly the reverse is not
No.
so, but the proposition I've put to you
Yes.
would be right, would it?
Yes, and the case in point, we would suggest, is a good example of that. And so, part of the argument on behalf of the appellant and part of the complaint, if you like, of the local planning authorities is that there is a mechanism that is available to the Secretary of State, even if it is thought not appropriate to use conventional planning applications. There is a further specific mechanism here, deliberately made available in order to address the situation of urgency. And the court will have seen from the provisions that, importantly, what this maintains is the role of consultation, so central to modern planning practice in terms of the involvement of the relevant local planning authorities, potentially parish councils as well, and consultees who may improve and inform decision-making processes. And so lastly, within this tab, we have section 296A, enforcement in relation to the Crown. And my lord, taking this provision in stages, see that subsection 1 is designed to provide absolute protection against anything that would otherwise be an act or omission by or on behalf of the Crown that would be capable of constituting an offence under the Act. Secondly, In addition to that protection, a local planning authority must not take any step for the purposes of enforcement in relation to Crown land unless it has the consent of the appropriate authority. One of the things that the judge did in his judgment was conclude that in fact it wasn't really necessary for the Secretary of State to rely on the earlier parts of section 296A because reliance on subsection 5 would have been enough by itself because of what's said there. We say that in construing this section as a whole, the key to it and the key to its proper application consistent with the purposes of the statute is that a local planning authority must not take any step for the purposes of enforcement. That phrase is used repeatedly within the section, and it's the key to its proper application. And so we say that that does apply to each of the following subsections. It's clear from subsection 4 that what it's directed towards is anything done in connection with enforcement of anything required to be done or prohibited under the Act. So that's where the judge focused back on section 57. So well, here is the general requirement for planning permission. Therefore, anything that involves a requirement for planning permission will be beyond this provision, apart from those things that are re-included.
As a matter of fact, merely, is there, I think I know the answer to this, but I'd like your confirmation of it. Is there any definition in the Act of the term enforcement?
No.
That was what I thought the answer was. There is no definition of enforcement as such.
No. Enforcement action.
Yeah, that's why I asked you the question.
So in the context of statutory changes that sought to reverse the previous position where the Crown was immune from the Town and Country Planning Act, the obligation to make a planning application is introduced, and the prospect of there being a degree of enforcement as the other side of that coin is also introduced in relation to acts of the Crown rather than simply acts that happen to occur on Crown land as before. And so what is being introduced here in terms of its statutory purpose needs to be effective. Enforcement has to be effective. The purpose of this statute is to ensure that planning control can be used in an effective way. And we say that when a focus is given to the purpose of these provisions, there is no justification for arriving at a conclusion that an injunction is prohibited by section 296A. And there is, well, every reason we say that that conclusion would be surprising and really absurd at the end of the day. There is every reason to think that injunctions should be available in an appropriate case. So we know from subsection 5 that a step taken for the purposes of enforcement includes entering land. Now, when the judge dealt with this issue, as we'll come on to see, he said that the provisions in relation to entering land were essentially added to what was already existing. The way that the statutory scheme is framed is not that way. The first thing that is mentioned is the entry of land, and one can readily understand why that is so in relation to central government land. There may be very real sensitivities about coming onto whether it's a local planning officer using their statutory powers, or whether it's happening under a warrant that's issued by a magistrate's court, under other provisions in order to facilitate entry to the land. So that's the first item that is included, and of course that's something that tends to follow on from the establishment of what the requirements and prohibitions are. So entry onto land for execution of works or things of that nature naturally follow on from an extant enforcement notice being in place. Bringing proceedings or the making of an application, those are things that again can be done in furtherance of steps of enforcement once the position in terms of requirements and prohibitions has been crystallised. So, for example, in the normal scheme of things, there can be applications in relation to recovery of costs for having to enforce on an enforcement notice.
Yes, but the bringing of proceedings. Leave aside all else, if you like, for the moment. The bringing of proceedings would include issuing a Part 8 claim.
Yes.
And it would include, within your Part 8 claim, actually, there was an application for an injunction, as I read it anyway. And then there was a separate application made for the injunction. And that would be the making of an application, leaving everything else aside.
Well, leaving everything else aside, I accept that.
Yeah.
And that's why it's so important to follow the guidance that we see in the Packard case about looking to the purpose.
Of course. I mean, the crux, but I'm trying to get to the crux of the issue. And the crux of the issue is whether, in the present case, the Section 187B injunction would have been a step for the purposes of enforcement.
That's where I say no.
Yes, but I mean that's the crux of the issue.
Yeah, indeed, yes.
Because if the answer is not no but yes, then 5B and C apply.
I accept.
Yeah. So the crucial issue actually on the jurisdiction issue, the crucial question goes to whether a Section 187B injunction is a step for the purposes of enforcement.
Yes.
As defined and non-defined, as it were, under Section 296A.
Yes.
That's the issue.
That's the issue. And I say that my law can collect from the other provisions in Section 296A reasons why an injunction claim is not an enforcement action for those purposes. And to look at what is permitted, so the issue of an enforcement notice is permitted, the issue of a planning contravention notice is permitted, the issue of orders under the Town and Country Planning Act, all of which will be steps taken by the local planning authority, with the local planning authority's judgment being involved in those issues, and being involved in the case of an enforcement notice on the same threshold, whether or not it's necessary or expedient to issue an enforcement notice. Same test applies in Section 187B. And so we know that those steps are permitted. Now, the purpose of those steps, the purpose of serving the planning contravention notice will be to acquire further information to allow the local planning authority to decide whether or not there is a breach of planning control. The service of the enforcement notice, unless and until it is challenged, has as its purpose specifying the steps that need to be taken in order to regularise the breach of planning control that has occurred. What those notices are directed to is crystallising the position so that both the local planning authority and the recipient of the notice, here the Secretary of State, know what the requirements and prohibitions are. What local planning authorities are not permitted to do is go a step further than that. Whether it is by seeking to issue a prosecution in relation to a failure to comply with an enforcement notice, or whether it is seeking to enter land in order to execute works, or for other purposes. Now, if that is a correct analysis of the purpose of section 296A and what it allows to establish what the position is, then an injunction under section 187B is superior to those notice procedures in at least two respects. Firstly, the court has an original jurisdiction, and whilst it will take into account what the local planning authority has said in its decision-making processes, it's not beholden to them, and the court will ultimately decide whether or not to issue an injunction based on the touchstone of proportionality. That is an improvement in analytical terms over what an authority is permitted to do under these provisions. The other clear benefit is that section 187B, as we know, provides the only part of the local planning authority's toolkit that allows it to act on an apprehended breach of planning control. So you may have a case, again, the instant one may be a good factual example, where there is a risk of what the local planning authority would say is a very serious breach of planning control arising. You can't serve an enforcement notice because it hasn't happened yet, and the situation's not, in reality, developed enough even for a planning contravention notice to serve much of a role. But what it can do is seek to establish the position using section 187B. And the ability to utilise that provision is, again, if one's talking about public authorities, to the advantage of both parties, because the local planning authority will know where it stands, and so too will whoever is in control of the Crown land.
We didn't look at section 187B, did we, on the way through?
My Lord, no. My Lord like to go back briefly to 187B.
Well, I think we ought to visit it.
My Lord, page 16.
Yes.
Grateful.
Where a local planning authority consider it necessary or expedient for any actual or apprehended breach of planning control be restrained by injunction.
Yes.
And you say that isn't enforcement?
I say that that is a preliminary step as far as section 296A is concerned. In the same way that serving a planning contravention notice or an enforcement notice would be a preliminary step to establishing or crystallising what the requirements and prohibitions are.
Sorry, a preliminary step, but not enforcement.
Yes.
Is that right?
Yes.
You drew a distinction with your service of notice by saying that's just the planning authority's important planning judgment on the issue, which is provisional, but obviously applying to a court for an injunction, that's more than provisional because the court has said yes or no.
The enforcement notice is only provisional in the sense that the local planning authority will set out the reasons why it considers there's been a breach of planning control, but unless until there is a challenge by way of appeal to the enforcement notice, or exceptionally by way of judicial review, the enforcement notice will come into effect, and at that stage there would be, in the normal case, requirements specified within the notice, a failure to comply with which is potentially prosecutable under section 179.
Thank you.
And so that is where I invite the court to focus squarely on the purpose, as the modern approach to statutory construction entitles the court to do, and to say, well, if these steps are allowed, what is the sense in prohibiting entirely the prospect of there being injunctive proceedings and prohibiting them unless and until the Secretary of State says, all right, I give my consent. So, as we indicate in our skeleton, what the construction on the other side does is essentially make the Secretary of State the gatekeeper of whether or not the court has jurisdiction. The court still can have jurisdiction in that case, but only if the Secretary of State says yes. That would be a most peculiar position to arrive at. It makes absolute sense in relation to entering the land and those kinds of steps, but it makes no sense in relation to a mechanism which allows the court in its original jurisdiction to determine whether or not an injunction should be granted.
Well, forgive me if this is a misunderstanding, but let me just ask you the question. The appropriate authority consent concept, which is clearly inherent in these provisions, leave aside the present debate about the status of section 187B, that concept of appropriate authority consent has inherent in it, doesn't it, the gatekeeper role?
It does, but in respect to matters where it is easy to see why. So, for example, in relation to entering the land, it is very easy to see why the Secretary of State may wish to say no to the use of those powers or to require an accompanying sign, so that if there are things that shouldn't be seen or actioned on the site, those can be the subject of control.
Yes, but it's not just entering land, is it? It's bringing proceedings and the making of an application.
My lord, yes, but those are, if one takes the examples that I was giving earlier of things that follow on from enforcement, such as going onto the land to execute works, bringing proceedings in order to secure a warrant for those purposes, or taking proceedings in order to secure a financial debt, then again one can see why. An important part of this purpose being successful, effective enforcement being successful, is that all of this statute is based on or sits alongside the convention that where the Crown is told what the state of the law is, or a declaration is made, or an injunction is made, the expectation is that there will not be a requirement for further steps. And that's an important part of analysing the purpose of these provisions overall and why there is no need for there to be the prospect of further enforcement of an injunction. Because once the court tells the Secretary of State what the position is, that will be sufficient. That's consistent with normal conventions. The first respondent confirmed in the court below that that would be the approach here, and I'm sure a similar confirmation will be forthcoming today.
Right. Let's just pause for a second. Does that really describe the main shape of your argument on the jurisdiction issue?
Well, it does.
We are dealing with the question of statutory interpretation.
Yes.
The principles as to which are well established. Principles apply to planning legislation. There's recent authority in this court to that effect. A case called Tidal Lagoon, Swansea Bay. There's no controversy about it. And the crucial question against the background of your submissions is the one that we isolated a few minutes ago.
Yes.
Now, we're not in any way precluding your developing the argument. We've seen the way in which it's put in the skeleton argument. Do you wish, what do you wish to do now? Do you wish to develop that argument more fully? Is it necessary to develop it more fully? How would you like to proceed?
Well, the other feature that I lighted on in my oral submission, but that is set out in more detail in the written submissions, are the consequences of the construction that the Secretary of State favours.
Yes.
And and we say why that construction would result in an absurd state of affairs, that it would be surprising and unreasonable in terms of how the statute would operate. And the court will be familiar from the guidance that the more unreasonable an apparent construction will be, so the less likely it is to be the correct one. And I simply would invite the court to focus on those issues as well, because once it's accepted that certain steps can be taken under 296A, why is the balance struck? The phrase that was used below, the balance has been struck here, suggesting that injunctions are outside. Why? If the court searches for a reason as to why that should be, there is no clear reason. And as I suggest, in fact, there are very clear benefits to allowing public authorities to have a situation crystallised by the use of the injunctive procedure.
Yes.
Well, then, moving on, in relation to Class Q, we were looking at page 32, the authority fund a little while ago.
Yeah.
And we see, my lord indicated, the presence of the word emergency as being the common theme within each of the three limbs of that definition. And my lord, the way that the judge approached it below, the respondent says not now, but if you go back to the judge's judgment, we suggest it is clear that the judge looked at the definition that's given in relation to emergency and considered that that was truly exhaustive of the position. And so the judge concluded, for example, that it wouldn't be appropriate for him and he wouldn't gain any assistance from looking at dictionary definitions of the word emergency. Now, we say that that was not the correct approach, that even where there is a more detailed definition, it is entirely permissible to look at various potential sources of aid in relation to statutory construction.
Yeah.
One of them is an authoritative dictionary.
Just, sorry to break in, because
Yes.
I think logically I ought to, or perhaps I ought to. There may be a threshold question here, which is, let's put it very simply, who decides what an emergency is in a particular case? This case included. There are potentially three options. The three options are as follows: the court, the applicant or developer, or thirdly, the local planning authority.
Yes.
So, do you think we ought to consider that threshold question first?
Well,
Because it may not be straightforward.
no. The way that it was approached in the court below was on the basis that if there were elements of planning judgment that were properly contained within Class Q, then applying normal principles and applying the Porter case, then within an application for an injunction under Section 187B, they would be decisions for the local planning authority.
Yes, but subject to the court's
Indeed.
intervention.
Yes.
But on what principle?
As I say, if the issue were one of planning judgment, then we say that the Porter guidance should apply in its normal way, and the impact of the Porter guidance therefore would be that the court should take that planning judgment as read and then proceed to analyse the situation from there to come to an ultimate view as to whether or not it would be proportionate to grant an injunction.
Yes, I mean, if we stand back again, we're doing a great deal of standing back, I appreciate. But standing back again on this question, what we know is that in the way that the planning legislation is structured, there are certain kinds of development for which planning permission is required on an application for planning permission made to the LPA. That's, if you like, the normal position.
Yes.
There are, however, certain categories of development which are called permitted development by planners. That's to say, development for which planning permission is granted, actually granted by a development order. The general permitted development order is the source of, I think all, if not most certainly, but I think all of that species of planning permission.
Yes.
In some of the classes of permitted development, there is a role for the local planning authority in determining an application for prior approval. There's been a good deal of litigation around that in recent times. In Class Q, there isn't that role. There is no ostensible role for the local planning authority, and that really gives rise to the question which I posed. So in the light, is that analysis all sound?
Well, yes, and that's why there a similar debate in the court below about this, and the way that it was left on behalf of the local planning authority was that if the judge considered that there was an element of the definition of satisfying himself about the definition that involved planning judgment, then that's something that he ought to defer to the local planning authority's judgment on. But I am not pressing hard against my Lord's provisional view that in fact when we look at Class Q, we're looking at the kind of case where the court will determine, as it does for other kinds of permitted development, whether or not what is proposed falls within the class of permitted development.
Yes, I mean ultimately the court has to decide that question. So the answer to my question is the court decides.
My Lord, that's certainly my main submission, and as I say, I'm not pressing hard against that. What I do press against is the suggestion that in relation to security or any other matters, that there is an enhanced role for the view that is expressed by the Secretary of State.
Oh, yes, that's a separate question, I think. I mean, obviously Mr. Brown will have his say in due course, but do you apprehend it is common ground? What you've said so far is common ground.
It will be common ground as far as it goes, but the
Yes, as far as it goes, yes.
But the Secretary of State's position below was that when there are matters which involve facts which the Secretary of State will say the Secretary of State has a particular familiarity
Yes, yes.
with, then that view ought to be accorded more weight.
Well,
we say that there's nothing in the statutory scheme that goes that way either.
Well, that's a separate issue actually in these in the appeal proceedings because it's raised by a respondent's notice.
Yes.
That point is, as I understand it anyway.
Correct.
That's what the respondent's notice does. So we'll come to that and you'll presumably deal with that as appropriate.
Grateful.
All right, well no, if that's rather laboured, forgive me. I just wanted to clarify the territory before we ventured into it.
And so, well, then turning back to pages 32 and following of
Yes.
Mr. Raji's
Thank you very much, yes.
And well, referred more broadly to the general permissive development order provisions, and my Lord may have seen, or the court would see from a survey of those proceedings, that there are, other examples where the word emergency is used without further definition. So it's used, for example, in the part dealing with transport, it's used in the part dealing with communications. And so insofar as it might be suggested that the word emergency is not capable of being sufficiently understood in its own right, there are examples within the very same order where the word is used. What is clear about the detailed formulation that's used here is that it's replicated in only a very limited number of places. And where it's replicated in its essentials is in the Civil Contingencies Act as primary legislation, both in Part 1 and Part 2, in the COVID provisions that were made, and in relation to the related provisions that were made that are now essentially time expired for local authorities to also act on an emergency. And their genesis was in COVID. So there are other examples of where the same formulation in substance has been used. And what ties all of those together are the kinds of events that have been envisaged when those powers have been used. So it is things like, as we see, just to apart from where we are at the moment, but if we move forward to consider the explanatory note in relation to the Civil Contingencies Act, because it's the best explanation of these provisions that we have, and it relates to where they were enacted in primary legislation and secondary legislation chronologically followed on from their enactment here. So if we turn to page 344 of the authorities bundle.
Thank you.
We have the explanatory notes, a permissible aid to statutory construction. And then going across to page 345, the commentary on the sections starts. There is a brief reference in note 10 as well to emergency being defined broadly.
Yeah.
But then paragraph 13, see subsection 1 within part 1, defines emergency for purposes of part 1, events such as a terrorist attack, disruption of fuel supplies, contamination of land with a chemical matter, and an epidemic could satisfy the definition should they reach the required level of seriousness.
Yes.
So that provides an indicator of the parameters of what emergency is intended to address. Unsurprisingly, a very similar note, note 39 in relation to part 2, is contained on page 348. But as the court will have picked up from our skeleton argument, that there is a difference in terms of the locational approach that is used between part 1 and part 2. And one can see it being described in paragraph 40. And this was another point that the judge analysed, but ultimately didn't accept in relation to the council's case below. What a comparison of these two different definitions of emergency shows is that when a very similar definition was incorporated into Class Q, the geographical basis upon which it was done was the more limited basis that appears in Part 1.
Yeah.
And that does serve a function. And one can underline that it's there to serve a function in construing the statute overall by looking at the planning practice guidance which, whilst the paragraph that we've supplied is from the 2014 planning practice guidance, because that paragraph hasn't been updated in the meantime, it is taken from Circular 02/2006, which contained materially the same text, produced in close contemporaneity.
0206 was it?
Yes, 02/2006. Produced in order to explain the implications of the various changes that were made, including Class Q. And so, bearing in mind that what we are construing is secondary legislation at this stage, the court is entitled as one indicator of its correct construction to take into account the views of the government department expressed about that specific change. So, if I now move back to the conditions that attach to Class Q, and they're set out on page 33 of the document.
Thank you. Yes.
And so we see there, development is permitted subject to the following conditions. The developer must, as soon as practicable, after commencing development, notify the local planning authority of that development. And again, as we suggested before the judge below, that is consistent with emergency being restricted and applicable to those kinds of cases where it is not possible to alert the local planning authority before operational development commences. It's a further indicator, and what I say about all of these indicators is that they all point towards a use of the natural and ordinary meaning of the word emergency. Something with a sudden and unexpected onset. What is not required, for example, by letter B, is to alert the local planning authority of an intention to commence development. And that could have been put in the alternative if it were thought important, because it's clear that this is a notice provision requiring notice after the event.
Just a second, sorry, you said something of a sudden and
Unexpected
onset.
Yes.
Yes, forgive me.
And by the way, we've provided the dictionary definitions of from the Shorter Oxford English Dictionary. Just while we're on dictionary definitions, one of the factors that the judge weighed against our construction of matters when it came to perhaps the geographical element of things was to distinguish between an event and a situation.
Yeah. Do carry on.
But if we again look towards dictionary definitions of what that means, then situation is perfectly capable of embracing physical difficulties within an item or structure. And looking at the way that this provision is intended to operate, it's not surprising that one should use one of the ordinary meanings within the dictionary to understand that phrase, because wherever there is a natural disaster, there will be presumably something that either has or is at real risk of being physically compromised. And so when there's reference to an event or situation, it doesn't have the context of being a wider, for example, a national issue in relation to whether or not sufficient provision is being made for asylum seekers. It's all capable of being understood consistently as a coherent provision as a whole, and taking on board the geographical limitations as well. That's not to say that an emergency can only happen on 1 hectare of a parcel of land. Plainly, an emergency can happen in a village, it can happen in a town. But the point of distinction is between something happening in a place and something happening across a country, for example, to take the two extremes of that position.
Yes, one could envisage a particular settlement, a village perhaps, being engulfed by a landslip or some other event of sudden onset, you say.
Yes.
Entirely unpredicted, but with disastrous consequences and an aftermath that requires acute intervention.
Yes.
But that would be an emergency, albeit only affecting, though in a tragic way, that particular settlement.
Yes, Mark. And when one looks at the guidance, and I appreciate we're straying into areas of documentation that may be less informative in terms of statutory construction, but they're still part of the background. We referred to other documents that have been produced in terms of providing guidance under the Civil Contingencies Act, and it is notable that they are of a piece in terms of the kinds of events that they seek to describe, and that we say this provision is really directed towards.
Yes.
So in terms of Class Q, then finally we move to the interpretation of Class Q on page 34. And this is where we have the provisions that are essentially taken from the CCA definition of Part 1 of the Act. Emergency means an event or situation which threatens serious damage. So in paragraph 1 is the qualification of serious damage, because paragraph 2 simply sets out ways in which damage may occur, but there is the additional threshold consideration of serious damage. The human welfare in a place in the United Kingdom, the environment of a place in the United Kingdom, or the security of the United Kingdom. And we, perhaps with the benefit of the notes to the CCA, which the judge below didn't have, say that there is an important locational element to that, which one can understand, firstly in the words that appear, but secondly in the context of what emergency means if one is permitted to look at the dictionary definition of that word. And so we see in paragraph 2, an event or situation threatens damage only, which is why we say that this part of the definition is not intended to expand the situations in which emergency can be applied, but deliberately to narrow them further to specific kinds of consequence, albeit a relatively long list, but again the same list that appears in the CCA.
Yes.
So there needs to be an event or situation which involves causes or may cause, and homelessness is the part of that definition that the Secretary of State relies on. And that is why the Secretary of State's case has to be predicated on non-fulfilment of the statutory duty, because if the statutory duty is still capable of being fulfilled, then homelessness will not arise. It will not involve cause, and it will not even potentially cause, i.e. may cause, homelessness, unless until that point is reached. And the evidence in the emergency statement we've looked at elsewhere simply doesn't make that proposition. Of course, in circumstances where there are natural emergencies, an earthquake, a flood, or something of that nature, the terrorist attack, then these things will happen, as it were, regardless of the power of a Secretary of State to make immediate provision, precisely because they're sudden, they're unexpected, and therefore these effects will arise.
Yes.
So, my Lord, again, in going through, as it were, the statutes, I've endeavoured to pick up the main parts of our submission in relation to Class Q. Unless there are any matters that the Court has for me on Class Q, I may just turn around and see if there's anything else that I'd like to develop further, otherwise leave things in writing. All I'm grateful.
Thank you very much. Thank you very much, Mr. Begman. Yes, Mr. Brown.
Lord, my lady, as the court knows, I resist the appeal. In my submission, Mr. Justice Waksman was firstly right to strike out the council's application for an injunction on the grounds that, in the light of what I say is the clear prohibition in section 296A, he had no jurisdiction in the matter. Second, in my submission, he was also right to conclude, in the alternative, as it were, that even if he had had jurisdiction, proposed use of RAF Wethersfield fell within Class Q permitted development rights, and consequently there would have been no breach of planning control which would have justified an injunction. My Lord, if I can start with the jurisdictional point, my learned friend has already shown the court section 296A, but I would ask you to go back there and if I could just highlight one or two aspects of it before we get into the detail of submissions. In the authorities bundle, it's at page 26, tab 1.
Yes.
My Lord, subsection 1, nothing's an offence, not an issue in this particular case. Subsection 2, local planning authority must not take any step for the purposes of enforcement in relation to Crown land unless it has the consent of the appropriate authority. And your lordships will note, and your ladyship also will note the way it's put, must not take any step. It is general in its terms. It is also a provision which in many cases will involve effectively the gatekeeper being the authority against potentially whom that action may be taken. It won't always be the case. It applies to Crown land, and there are circumstances in which work may be done on Crown land but not by the Crown. In those circumstances, the appropriate authority may be slightly more removed from it. But even in cases where the appropriate authority is the body carrying out the work, it is the gatekeeper under subsection 2. People may raise their eyebrows about it, but the legislation is perfectly clear in that regard. Subsection 4, a step taken for the purposes of enforcement, clearly picking up on the language in subsection 2, is anything done in connection with the enforcement of anything required to be done or prohibited by or under this Act. So again, in my submission, the words used, general, anything done in connection with the enforcement of anything, and then required to be done or prohibited by, and I just ask your lordship and ladyship at this stage to underline or note by or under this Act as well. One then has in subsections 5 and subsection 6 specific inclusions and specific exclusions from the provisions. In my submission, my lord, section 296A subsection 2 is squarely engaged in this case. In terms of the matters that are not in issue, just clearing away the simple points, this is an injunction which relates to Crown land. The appropriate authority is the second defendant, which certainly at the time was the owner of the site. when the claim was lodged, and the claimant doesn't have, and indeed has never, as far as we are aware, even sought the MOD's consent. Similarly, in terms of matters that are not in dispute, in the light of the answer that Mr. Beglan gave Lord Justice Lindblom about subsection 5, it's quite clear that within any ordinary sense, and subject, of course, to the question about what is a step for the purposes of enforcement, but that what has happened in this case both involves an application, which is caught by subsection 5C, and also the bringing of proceedings, which is caught by subsection 5B. My Lord, I would say that flows simply from the wording of 187B. In any case, a local authority may apply to the court. You apply, you make an application. So those matters are common ground. So in those circumstances, the issue is whether the application, whether the bringing of proceedings is a step for the purposes of enforcement. And in my submission, it plainly was. My Lord, can I start with a point just about the structure, because it relates to an argument advanced by Mr. Justice Waksman in his judgment, which flows from subsection 4 and subsection 5. Subsection 4, your Lordship's seen subsection 5. My Lord, if one stands back from this, it is, I can see, arguable, it's not entirely clear whether subsection 5 is a freestanding category of things which are a step for the purposes of enforcement, one that operates independently of subsection 4, or whether one has to read the two sections together so that it's only proceedings or applications which are done or relate to things done or prohibited by or under the Act. And it's fair, my Lord, to say that in my argument in front of Mr. Justice Waksman, I put the case squarely on the latter basis. I worked on the assumption that subsection 5 is coloured by and influenced by subsection 4. The court will note Mr. Justice Waxman's conclusion, and in particular it's his paragraphs 64 to 65, that in fact, if you are within subsection 5, it doesn't matter whether you are within subsection 4 at all. My Lord, I don't press, I'll draw your Lordship's attention to it. It's there in the judgment. I don't press the point because in my submission this clearly falls within 4 in any event. And my Lord, I can see that there would be some difficulty in that approach, in that while one might think that if an application is made by a local planning authority, it's unlikely that it won't involve planning matters. I mean, it's conceivable that there may be applications and proceedings that are brought which turn on matters that aren't necessarily prohibited by the Planning Act. So I entertain, I note the point there, it's helpful to me, but I'm not going to necessarily adopt it lock, stock and barrel for that reason. In my submission, I can get home quite clearly and quite simply on the basis of subsection 4. In that regard, I've already drawn the court's attention to the breadth of the subsection. It bites on anything done in connection with the enforcement of anything required to be done. And in that regard, my Lord, simply standing back before one gets into the detail of what is it that is required, what is it that is prohibited, the court may think it's of some significance that section 187B lies within part 7 of the Town and Country Planning Act, the entirety of which is headed enforcement. 187B is a provision in the enforcement section of the Act. And on that basis alone, I would say it's not unreasonable to conclude that it is connected with enforcement. But, my Lord, that is, in my submission, confirmed by the fact that section 187B can only be invoked where a local planning authority considers that there is or is likely to be a breach of planning control. And that flows directly from the wording of 187B itself, where a local authority considers it necessary or expedient for an actual or apprehended breach of planning control to be restrained. That's the, if you like, the first question that a local authority needs to address before going down that route. So what then is a breach of planning control? The answer to that is found in section 171A, which the court has at page 12 of the authorities bundle. it's subsection 171A1, and the court will note section 171A, the heading expressions used in connection with enforcement, and it has two expressions which it defines, both of which are in connection with enforcement. Mr. Begland understandably took you to subsection 2, which is the definition of taking enforcement action. But subsection 1 is concerned with a breach of planning control. And the court will note subsection 1A, the purposes of this act carrying out development without the required planning permission, or failure to comply with a conditional limitation, constitutes a breach of planning control. And so we have here a definition of breach of planning control in a section which is dealing with expressions in connection with enforcement. In connection, again, being the language sort of wording that we see in section 296A, subsection 4. And in simple terms, my lord, in my submission, if a breach of planning control is an expression used in connection with enforcement, if section 187B is a mechanism for restraining a breach of planning control, it is very difficult in my submission to see why that section is not a step in connection with enforcement. Moreover, that argument or the linkage with what is required to be done or prohibited by under the Act is also, in my submission, clear. The court will note that in the terms of section 296A4, it's sufficient that something is either required to be done or prohibited by under the Act. Either one of those two will do. But if I start with what is required to be done, Mr. Begland has already shown the court section 57 of page 3 of the bundle. Planning permission is required for the carrying out of any development of land. The word used, very clear, it's a requirement under the Act, or a requirement of the Act. And that is, in my submission, reinforced by the provisions on enforcement. A moment ago, I took the court to section 171A, page 12, the definition of breach of planning control, 1A, carrying out development without the required planning permission. Again, the word requirement there quite clearly set out in terms of what is a breach of planning control.
Mr. Brown, I'm sorry, forgive me. If you could go just a little slower, that would help the court.
My lord,
it's only because, as you may have noticed, I'm writing. My colleagues, being far more modern than I am, are typing.
My lord,
I know that I can write.
Forgotten the first rule of advocacy, which is always watch the tribunal's pen.
But I also know that I can't write as fast as once I could. So if you could go just slightly slower, that would help me.
Certainly.
Yeah.
So, my lord,
I'm sorry to interrupt.
No, I apologise that I was going too quickly, my lord. So, one sees there the section 171A, again, the words required planning permission, they're linked with breach of planning control. Again, if one is asking the question that is posed by section 296A, in other words, what is it that is required to be done or prohibited by under the Act? The requirement is to obtain planning permission for development. And, my lord, that definition in section 171A, as your lordship will know, have seen, flows through into what it is that a local planning authority enforces against. We don't have in the bundle section 172, which is the power to issue an enforcement notice, but that power is dependent upon there being a breach of planning control, and the court has seen that exactly the same thing is true of 187B. The power to apply to the court is dependent upon the local authority having first concluded that there is a breach of planning control. Breach of planning control, carrying out of development without the required planning permission. The language in either case is the same, and in either case it takes you back to the core requirement imposed by Section 57. Now, well, that's the legislative framework. I want then, if I may, to relate it to the basis on which the claim was brought in this case. And for this, I'd ask the court to take up the core bundle.
Do you want us to keep the legislation available?
Keep the legislation available, my lord. We'll need to go back into it shortly. But within the core bundle, if I can show the court the brief details of the claim, which start at tab 3, and in particular, if one goes to page 45, and under the heading the land is identified, but at paragraph 5, the claimant tells us the proposed development of the land for those purposes would include a material change of use requiring planning permission. Same thing in paragraph 6. The claimant apprehends the first defendant will carry out acts of operational development which in themselves will require planning permission in their totality. There's then a description of where the land lies within the area, what it's connected to, but at paragraph 10, the land does not have planning permission for the proposed development. Similarly, if one moves forward to page 49, under the heading the apprehended breach of planning control, 2/3 of the way down the page, paragraph 26, none of the land has been granted planning permission for residential use or for the placement of asylum seekers in medium-term accommodation. And then, if one turns to paragraph 35 at the top of page 51, the claimant has made its position clear that, amongst other things, it considers that planning permission is required for the proposed development. And then, paragraph 38, the need for an injunction. The claimant considered and considers that it's necessary and expedient to seek an injunction preventing specified breaches of planning control, in particular the use of the land for the placement of up to 1,700 male asylum seekers. And so, my lord, I could show you references also in the witness statements, but they were there at the time. But for present purposes, I hope the brief details of the claim are sufficient. The same or similar references can be found in Mullin and Friend's skeleton argument to this court, in particular paragraph 3 at page 19 of the bundle. But, my lord, with those references in mind, if one stands back and asks, what is it that the Act requires to be done and which the Council was seeking to enforce, the answer in my submission is clear. The Act requires the Home Secretary to obtain planning permission or to have planning permission before carrying out the proposed development, and the whole basis of the claim below was that the claimant was seeking to take enforcement action against what it believed was the failure to comply with that requirement. My lord, if I'm right about that, then it's irrelevant. It's certainly not necessary for the court to go on and decide whether the Act also specifically prohibits development without planning permission. That would then engage the second limb of subsection 4. But, my lord, if I do need to go that far, I respectfully agree with what Mr. Justice Waksman has said at paragraph 60 of his judgment, that carrying out development without planning permission is prohibited by the Act. My lord, in that regard, I accept that the Act does not make a breach of planning control a criminal offence, but it is clearly unlawful. That is why it is described in section 171A as a breach of planning control. It is why it is possible to take enforcement action against it. And I know my Lord Justice Lindblom will be familiar with section 191. It may be that the other members of the court are as well, but either way, can we look it up just to see how this fits with what the Act regards as lawful? Page 17 of the authorities. It's dealing with certificates of lawfulness of existing use or proposed development. Subsection 1 provides a right to apply to a local authority for a certificate that development is lawful, but for my purposes what is relevant is subsection 2. For the purposes of this Act, uses and operations are lawful at any time if no enforcement action may be taken in respect of them, whether because they didn't involve development or require planning permission, or because the time for enforcement action has expired, or for any other reason. And on that basis, in my submission, it's absolutely clear that certainly until the time for taking enforcement action has expired, development which is carried out without permission is unlawful. And in that sense, while I recognise there's nothing in the Act which specifically says you must not do this without permission, Mr. Justice Waksman was entirely right to conclude that carrying out development without permission is effectively prohibited. But I stress, I don't need to go that far, the court doesn't need to go that far if I'm right about there being a requirement to obtain planning permission, and that being within the scope of subsection 296A4, then that is sufficient for present purposes. The Council is taking action to secure the enforcement of the requirement under the Act to obtain permission.
May I just ask a question before you leave 192A? You've told us that and that provides that for the purposes of the Act, uses and operations are lawful if no enforcement action may be taken. And you've said they can't take enforcement action against you. Are you therefore contending that your development is lawful on that basis?
Entirely. Yeah. But not on the basis that I'm outside the time limits for enforcement, on the basis that the Secretary of State has permission under the permitted development, it is an important point. My learned friend, I'll pick this up later in terms of the architecture of the Act, but there's a sort of reference to the fact that if you go by way of permitted development rights, you avoid the need for consultation and all of these things. It is essential the court understands, as I'm sure it does, that the GPDO grants planning permission. It is a grant of planning permission on a nationwide basis. And indeed, large amounts of development are carried out pursuant to permitted development rights without any consultation whatsoever. That is as much a normal part of the architecture of the Town and Country Planning Act as the process of applying to an authority for permission.
You're answering that by reference to Class Q.
Class Q, my lord, yes.
But if you look at your submission that you just made under 2A, you've told us that no enforcement action may be taken, and therefore it's lawful. So you don't even need Class Q on that argument that you're putting to us.
Well, no, my lord, my lord, enforcement action, taking enforcement action, is defined by section 171A subsection 2. And that is an enforcement notice or a breach of condition notice. Neither of those is prohibited by section 296A because they fall within subsection 6. Those are steps which a local authority can take which do not involve the commencement of proceedings or the making of an application. One goes back to 296A at page 26, subsection 6, a step taken for the purposes of enforcement does not include service of a notice, the making of an order. So an enforcement notice, which is taking enforcement action, is allowed under the provisions of 296A.
Thank you.
Does that help, my lord?
Yeah, very helpful.
I'm grateful. So,
I mean, of course, all these submissions you're making on the basis that your case on Class Q stands anyway, and so you've got a defence.
yes.
You've got a defence to the Part 8 claim, you've got a defence to the application for an injunction. But we're looking at the activity of the local planning authority and whether that activity, i.e. making the Part 8 claim, applying for the Section 187B injunction, whether that activity falls within the scope of the concept of a step taken for the purposes of enforcement.
Indeed. My lord, I hope it is clear. If not, I make it clear. The Secretary of State is not seeking to hide behind Section 296A. Throughout the whole of the submissions that went to the Minister, the Secretary of State in the period January up to March, what was done was premised on the fact that this was within Class Q, it had the benefit of permission and would therefore be lawful. At that stage, you might say, well, if I'm confident about that, why do I need 296A? Why have we troubled the court with it? 296A is a jurisdictional provision.
Well, Section 296A, when it is raised, causes the court to ask itself whether the court, has jurisdiction to hear the proceedings, and that is the provision inserted in the Act by Parliament.
Indeed.
Could I just take you back a step? I was about to ask you about the concepts of requirement and prohibition. It could be said, I don't know, could it, that one is the corollary of the other, at least the requirement to do something may in part be generated by the legislative reality that if one doesn't do it, or if one doesn't, the doing it without having got the requisite permission is prohibited, and the requirement and the prohibition are correlative.
My Lord, yes, and that in essence is the basis on which Mr. Justice Waksman concluded that this was a prohibition as well as a requirement.
Yes, I suppose you could have a requirement that isn't also the corollary of a prohibition, but you say that he was right to decide it in that way.
My Lord, some of the examples that my learned friend gives of a requirement would, it's true, not involve a prohibition. So, for example, as your Lordship will know, if an enforcement notice is issued, one of the things it will do is specify the steps which are required to be taken. Those things may involve the reinstatement of land, or they may involve any number of things. But so there's a clear positive requirement. It's difficult to extract a corollary prohibition out of those. But there will be circumstances in my submission, and the requirement to obtain planning permission is one of them, where the flip side of that, the other side of the coin, is that there is effectively a prohibition. But I go back to the point that I hope I've made clearly enough to the court, that in my submission, it's enough that there is a requirement. I don't have to go as far as Mr. Justice Waksman did, but if the court is so interested in my submission, he was entirely right for the reasons he gave. But this is a situation where there is a requirement under the Act, and the Council, its entire claim was premised on a complaint that requirement had not been complied with. So, look, can I turn to my learned friend's arguments as the reasons why the submission I've just made is wrong? And I've made the submission squarely within the simple wording of the provisions. But he says, in his principal argument, is that when subsection 4 refers to a step for the purpose of enforcement, anything required to be done or prohibited by under this the Act, those words are limited to cases where either the local planning authority or possibly the court has already issued some kind of notice or order, possibly of the kind which is allowed by subsection 6, which details exactly what must be done or what must not be done. And on that basis, if I understand him correctly, he says the Council could issue a stop notice or a discontinuance notice or an enforcement notice, but it couldn't then come to this court for an order or an injunction seeking compliance with that. You could issue the enforcement notice, but you can't then come to court to do it. I'm not entirely clear where he lies in relation to 187B, but the logic of that would be that there would be circumstances in which you could not use 187B, even on his case. So, for example, if there is an enforcement notice requiring things to be done, and the local authority, rather than seeking to prosecute, chose to come to this court for an injunction, which is not an unusual course of action in those circumstances, there would be a notice which required things, and coming to court would be making an application in relation to that, which would be barred. So even on his analysis, in my submission, it's plainly not the case that 187B is totally excluded. But in my submission, there is no basis for confining subsection 4 in the way that he suggests. In particular, in my submission, that approach requires the court to read words into subsection 4, which are simply not there. If it had been intended to limit subsection 4 to non-compliance with notices or orders, whether made by the court or the local planning authority, subsection 4 could have said that very, very simply and plainly, but it does not. And indeed, not only does my learned friend's submission involve reading in words which are not there, in my submission it's contrary to the very clear wording that is used. And in that regard, I've already made the point on more than one occasion that the language in subsection 4 is broad. Anything done in connection with anything required to be done. And I say this, the restriction which he seeks to impose doesn't sit comfortably with that. But also, as Mr. Justice Waksman pointed out at paragraph 58 of his judgment, subsection 4 doesn't simply refer to things required or prohibited under the Act, which may be an appropriate way of describing orders and notices which are issued pursuant to powers under the Act. Subsection 4 also refers to things prohibited by this Act, which in my submission imports a notion that the prohibition or the requirement comes direct from the Town and Country Planning Act itself. It's not dependent upon some other thing being done under the Act, first of all. In my submission, the appellant has produced no answer to that point, which flows clearly from the wording that is used in subsection 4.
Could I ask you just to pause? This is to ask you to clarify something in your skeleton argument.
My lord, if I can. I hope I can.
Well, I think it may just be a typo. I'm not sure. Find it now. I'm very sorry. I can't.
No, not at all.
Yes, here it is. It's a paragraph 35. I wonder whether an extra word has crept in or been left in drafting that. A's response to this is that section 296A4 should be read in a way which limits the words the enforcement of a thing required to be done or prohibited by or under this Act to things which are required to be done or are prohibited by a notice or order issued under together.
Take together out, my lord.
It's just that, is it?
The together is, yeah, under.
Well, then we've got to take together with.
Together with, yes. Yes.
There's nothing else left out.
No, that's a typo. I do apologise.
No, that's all right. It's just when I read it, I couldn't quite make sense of it. That's all you meant to say. That's
all I meant to say, and I hope, my lord, that that's covered by the submission I've just made to the lord, and indeed the reasons for it are.
No, it's clear. It's clear.
I'm grateful.
I just couldn't make sense of it with those words in.
No, well, I can understand that entirely.
Okay.
But, so my lord,
thank you.
That's the submission I make about simply looking at the wording. I do go beyond that. My learned friend talks about outcomes being illogical, but in my submission, the approach that he urges on the court is also problematic, if not illogical. It is inherent in his submission that if the Home Secretary, or indeed any limb of the Crown, was doing something which was expressly prohibited by a notice issued by the local planning authority, or if they failed to do something which was specifically required, that this court would be powerless to act in response to that. That's the logic of his argument. Those are, in my submission, what Mr. Justice Waksman, at paragraph 57 of his judgment, what he described as paradigm cases where the language of requirement or prohibition is found.
Sorry, which paragraph?
Paragraph 57, my lord. And one can understand why he describes them in that way. They are not always, but frequently cases where a failure to comply with the notice would ordinarily be a criminal offence. And these are the kind of examples of what, if one were to adopt the language that one sees used, for example, in Porter, one might describe as a flagrant breach of planning control. You have been told by the local authority what you've got to do. You have specifically not done it. That is as clear a breach of planning control as you can get. But in those cases, as I understand it, Mr. Beglan accepts that the court would be powerless to act. So his submission to the court therefore depends on the proposition that because this case is not a paradigm example, because it's something less than the most flagrant breach of planning control, the court can act. And I say that with respect to him, that's manifestly absurd. If a claimant can't seek an injunction against a flagrant breach of planning control, it is very difficult indeed to fathom the logic of an argument that it can obtain an injunction for something less. Well, there's an added reason why that argument produces a logical difficulty, because my learned friend works on the basis that, at least in some way, shape and form, that in these proceedings, he can get a High Court injunction. But nonetheless, my lord, this court does not act in vain. And the question then would be, well, if the court were to grant an injunction, where would it be if the local authority came back on proceedings for contempt? And on Mr. Beglan's own argument, he would not be able to do that because the courts, the injunction itself, would be providing the level of detail that would be sufficiently specific to bring the prohibition of 296A4 into play. So in those circumstances, he could not ask the court to enforce the injunction. And I say that would be a very strange situation where this grants an injunction but is then powerless to do anything about it. That's the first and the primary argument which is set against me, that one has to limit the scope of subsection 4, and I say it involves reading in words that aren't there and are inconsistent with the words that are. The second limb of Mr. Beglan's argument draws attention to the definition in 171A subsection 2, taking enforcement action. And it indicates that one should read 296A in subsection 4 in a similar light, or that this goes together with his argument that 296A4 relates to steps required or prohibited under things which constitute taking enforcement action. Again, in my submission, it's an argument that goes nowhere. Your Lordship and Your Ladyship already have the point that under section 171A, there are two separate expressions in connection with enforcement. Taking enforcement action is only one of those, and significantly, that is not the expression which is used in 187B. 187B uses the first of those expressions, breach of planning control. But, my lord, more important than that is the fact that if, in subsection 4 of 296A, if the court had meant to use the same concept, taking enforcement action, it is a term which is specifically defined in the Act. It is used in other provisions of the Town and Country Planning Act, and my learned friend and I have both shown the court section 191. It's also found in section 171B, concerned with time limits. taking enforcement action defined in subsection 171A and then understandably used elsewhere in the Act, but critically not used in section 296A. Section 296A does not use the words taking enforcement action. Instead, it talks about steps taken in connection with the enforcement of. And in my submission, that is and should be taken to be a deliberate choice of different words. And as Mr. Beglan said in response to Lord Justice Lindblom's question, the Act itself does not define enforcement as a concept on its own. It defines taking enforcement action, but it does not define enforcement. And if one contrasts that position with subsection 6 of 296A, step taken for the purposes of enforcement does not include service of a notice, the making of an order. That exclusion in subsection 6 effectively covers the whole of taking enforcement action. In those circumstances, if 296A is clearly saying you can take enforcement action within the 171A sense, in my submission, far from indicating that 187B isn't in connection with enforcement, it confirms the submission that it is. It's different from taking enforcement action. It is nonetheless a step in connection with enforcement action. It's been urged on the court that that would produce a surprising result in which there would be effectively no way of bringing the Crown to heel. But, my Lord, that argument starts on the basis of an expectation that the Crown should be subject to planning control. And critically, that is not the backdrop against which Section 296A was enacted. The court will have seen, in my own friend's skeleton argument, 296A was introduced along with the other provisions which brought the Crown under planning control, was introduced in 2004. Prior to that, Crown was not subject to the planning regime at all, and indeed, under the old Section 296, prior to the 2004 amendments, and that was the document that came in as an errata to the bundle, my Lord. The old 296, which I don't know whether it's been kept out as an errata or whether the courts slipped it into the bundle in what would have become page 25. But under the old Section 296, resort to Section 187B was expressly prohibited under those provisions. And so if one starts from the basis that we have legislation which is amending a world in which, or changing the world in which the Crown is immune and there is no possibility of an injunction, I say there is nothing illogical at all about 296A on the basis that it is not turning the whole of that world on its head and making the Crown subject to planning control in every conceivable sense. I say it's entirely understandable that there is something of a compromise there. Previously, there was complete immunity, but it's not surprising that in bringing the Crown under planning control, some element of freedom, some restriction on the ability to enforce against the Crown was retained. And it's for those reasons I say that Mr. Justice Waksman was right to conclude that this claim was barred by statute and that it should be struck out. My Lord, that brings me to a convenient moment, unless the court's got any particular questions about my submissions on 296A, which I can deal with now or after the short adjournment, whichever is most convenient for the court.
No, we have no questions at this stage, Mr. Brown. Thank you very much. We just take stock. The way things have gone, we, I think, have no fear that we'll be under any pressure of time today. How much longer do you think you require, Mr. Brown?
Well, my submissions are almost exactly 50-50 on the two issues, my lord. So at most, I would hope an hour this afternoon. Depends on whether the court has questions, but I would anticipate an hour.
About an hour. And how are you proposing? You'll deal with the respondent's notice in your submission?
My lord, yes. The court. I hope the court's understood. I don't quarrel with the way in which Mr. Justice Waksman approached it in this case, which is that the facts were not in dispute, and most of the points made by, in fact, not all of the points made by the claimant about Class Q were matters of interpretation. What is the right approach to interpretation? And on that basis, I don't need the respondent's notice. The respondent's notice is as much, if you like, an exercise in caution, because I note my learned friend Mr. Beglan has the argument that to the extent that there is a judgment to be made, there should be deference to the local authority. My primary submission is there is no need for deference. Mr. Justice Waksman was right. If, however, there is an issue of planning judgment to be made, bearing in mind the particular nature of these development rights and bearing in mind that it is grouped together with other kinds of emergencies such as national security, and I would hope, my lord, that if we were in the realm, I know this isn't a national security case, but if we were in the realms of national security, the idea that there should be deference to the local planning authority is one which would be, in my submission, surprising. And there may be circumstances in which a similar argument could apply to, for example, the seriousness of an emergency, and where, if I had to go there, I would submit, if anything, the deference should go the other way. But I don't need it as part of my primary case.
Well, you'll decide whether you're going to rely on the respondent's notice.
Indeed. But I hope, my lord, that explanation is
Yeah, no, that's very helpful to know at this stage. Right, well, fine. Well, we'll start again then at 2 o'clock. Thank you very much.